Hi guys, my name is Curtis Walker, and I'm going to do my discussion one for the University of Arizona class. Forgive me, I have a busy life, and so this is what I could come up with to wear. I'm not in Colombia, but I am rocking the Colombia cap. Viva Colombia! All right, so let's just dive right into it, and I'm going to be doing the Carson versus Makin case, and let's see what we got. All right, so you see on the right side of the screen, I'm doing Carson versus Makin 596 US 2022 147 Supreme Court 187 2022. Hope I got the sites right. So we're going to do the agenda, introduction, facts, issue, holding, discussion, ruling, summary. So, introduce the case. Maine, the state of Maine, enacted a program of tuition assistance for parents who live in school districts that do not operate a secondary school of their own. Under the program, the parents are able to designate a secondary school that they would like their kids to attend to, whether that be private or public, and that the school district would then transmit payments to that school to cover the cost of tuition. Most private schools are eligible to receive these payments so long as they are non-sectarian, and the question is presented whether this restriction violates the first exercise clause of the First Amendment, the free exercise clause of the First Amendment. So here are the facts. So Maine relies on the school administrative units to ensure that each child has free education. To meet those requirements of the SAUs, without its own public school, you can do one of two things. You can contract with a secondary school to provide the privileges, or two, you can pay the tuition of another school where the student is accepted, regardless whether that student or school is a public or approved. Regardless, that secondary school must be public or approved private school. The bullet number two is to be an approved school, the private school must meet state requirements for attendance, and it must be non-sectarian in accordance with the First Amendment. Point three, so there were these three families, the Carsons, the Gillises, the Nelsons, that live in these school administrative units that don't operate a secondary school of their own, but provide tuition assistance to anyone that wants to send their child to an approved private school. Bullet number four, the three families then opted to send their kids to private schools that are accredited but don't meet the state requirements, so it gets in a little gray, because they are religiously affiliated. The schools are thus not eligible for tuition assistance. Bullet number five, the families then filed suit in the federal district court, arguing that the non-sectarian requirements violates the Constitution as applied. And then on cross-motion summary judgment, the district court granted judgment to the state, not the plaintiffs, denying the plaintiffs. The U.S. Court of Appeals, First Circuit, affirmed on precedent, citing that the other cases that are decided by the U.S. Supreme Court, they know of them, but the holding those two cases do not produce a different outcome. I just got to slow down. I'm talking too fast. So here is the issue. Does the state law prohibit, and this is a direct quote from Oyez, does the state law prohibit students participating in an otherwise generally available student aid program that they're allowed to choose their own, that aid their attended schools that provide religious or sectarian separated instruction that violates the religious clause or equal protection clause of the United States Constitution? That is the issue at hand. Affirmative by the United States Supreme Court that yes, it does violate the First Amendment. So how did we get here? So basically, the cases that set the precedents were Trinity Lutheran Church of Columbia, Inc. versus Comer. And in Trinity Lutheran Church Inc. versus Comer, the court held that the free exercise clause does not permit Missouri to discriminate against otherwise eligible recipients by disqualifying them from public benefits solely because of their schools are religious in character. And then in Espinoza versus Montana Department of Revenue, the court also ruled that barring any government to any school, that you cannot control it in whole or in part by any church, sect, or denomination, which also violates the free exercise clause, because it prohibits families from otherwise being available to scholarship funds at religious schools, which is kind of a gray area. So in basic, it's saying that, all right, so if you have this state rule that you're going to provide tuition assistance, you can't decide who you want to provide it for. You can't decide to say, well, if this school is religious, then we're not. If this school is private, we will. If this school is public, then we will. If you have a state law that's, you quote unquote say is defined then you must apply that across the board. You can't pick and choose which schools that you want to, even though it may seem like it's a gray area, which the dissenting justice actually address, because the concept would then be, well, is the state supporting religion? And it's not supporting religion. It's supporting the student who just happens to choose to go to a religious school because that's the school that's available in their area. All right, so if you apply the free exercise clause of the First Amendment, how does that precedent apply? Applying it, Maine cannot choose which private schools it subsidizes, regardless if those schools are sectarian or religious in nature. So the free exercise, the ruling is the free exercise clause of the First Amendment, according to LexisNexis.com, protects against the indirect coercion or penalties on the free exercise of religion and not just outright prohibitions. In particular, a state violates the free exercise clause when it excludes religious observers from otherwise available public benefits, which means, as this school, right, these are religious children that are going to religious school, but the benefit is public in itself because they happen to choose a school that is sectarian or religious in nature. You cannot exclude those benefits from them because of that choice when you did not state that in your law. And even if you did state that in your law, it would violate the free exercise clause of the First Amendment. So a state may not withhold unemployment benefits, for instance, on the grounds that an individual lost his job for refusing to abandon the dictates of his faith or her faith. All right, so writing the majority opinion, Justice Roberts, the Chief Justice, states that Maine's sectarian requirement for the otherwise generally available tuition assistance payment violates the free exercise clause of the First Amendment, which we just covered a minute ago. So regardless how that benefit and restriction are described, the program operates to identify and excludes otherwise eligible schools on the basis of their religious exercise, which basically says Maine has this program, but if you're a religious school, we're not paying for those funds. So it specifically is designed to discriminate against schools that happen to be religious, even though your statement says that you're willing to pay the public tuition for anyone, regardless of this, regardless. So the judgment of the Court of Appeals is reversed, and the case is therefore remanded for further proceedings consistent with this opinion. Dissenting Justice Breyer, and Justice Sotomayor state that Maine wishes to provide children with all public education, and this wish embodies in significant part the constitutional need to avoid spending money to support what is essentially the teaching of practice in religion. However, in the case, I don't think that is really an issue, in my opinion, because it's about public education and not religious exercise and practice. Just because you're going to a religious school does not necessarily mean that you're not getting a quantitative education. So when Justice Breyer says this, in my opinion, I believe that it's a loophole, simply just taking all of the religious institutions and putting them into a mosh pit and saying, no, you can't do that because they're religious. That is not reading the text and well as the will and the design of the First Amendment. So the need is reinforced by the fact that they are today a nation of more than 330 million people, as Justice Breyer goes on to state, who ascribes to over 100 different religions. In that context, state neutrality with respect to religion is particularly important. So religious clauses give Maine the right to honor that neutrality by choosing not to fund religious schools. But again, the argument is not whether the school is religious. The argument is really about the choice of the individual. If the individual chooses a school, regardless whether it's religious or not, you have stated you will fund that secondary option for them. Because the school is a religious school and you choose not to, now they're falling into a form of discrimination, and now you're violating the First Amendment. Justice Sotomayor goes on to state that, basically what a difference 5 years makes, because in 2017, when this case came up, Trinity versus Lutheran, the court was leading us to a place where separation of church and state is a constitutional slogan, not a constitutional commitment, her words. So the court basically is taking the state to a place where the separation of church and state becomes a constitutional violation, basically saying, well, we can't do this because that's a religious organization, so we can't support them. Yet there are plenty of government funds, and we're getting into a whole other issue, that do support institutions that provide services to the public, even though those institutions are religious. So if the state can't offer subsidies to its citizens without being required to fund religious exercise, in this case, they're confusing the service as in public education in contrast to the religious practice, basically saying that the state is actually funding religious practice. It just so happens that the school is religious in this institution. So the state values historic anti-establishment interests more than this court does. It will curtail the support it offers to its citizens for a growing concern. And she goes on and she says she respectfully dissents. I'm running out of time rapidly. So the summary is, In Carson versus Makin, there was a 6-3 decision. The court said that Maine officials need not allow more faith-based private schools to receive public education funds. The justices in the majority said that the ruling should have been unsurprising, given other recent cases involving religious schools, while the dissenters argued that Carson v. Makin represented a major breach in the wall of church and state. And now I will state that I agree with the court. And I will tell you why. So, and Chief Justice Roberts states that, this case really involves a challenge in the program that, there are kids that are in these rural districts and they can't get an adequate education. They happen to find another school and the state is willing to support that. So, Chief Justice, he's the writer of the majority opinion, and he basically is saying that he treats the case as nothing more than the same application in the law in the cases of Trinity Lutheran versus Comer and Espinoza versus Montana Department of Revenue. The free exercise clause basically protects against indirect coercion and penalties on the free exercise religion. In this case, because it happens to be a religious school, you're going to penalize them. This is where Justice Roberts brings that gray area into focus, instead of saying, hey, just because they're religious school, we cannot penalize them and we still must pay the tuition. So the principles applied in Trinity versus Lutheran suffice to resolve this very same case, he states, and it goes on to say that tuition assistance payments for any family whose school district does not provide a public secondary school is just a neutral benefit in which public funds flow to religious organizations through independent choices of private benefit recipient, and it does not offend the establishment cause. The court then goes on to rebuke the lower court, the district court, and says that the court is basically recharacterizing the tuition assistance program, and that it does not distinguish this case from Trinity Lutheran. Again, I said that the court is trying to go around the fact that it happens to be a religious school and saying, no, because it is a religious school, we cannot the state cannot pay for the tuition. But no, the state has stated that they will pay for tuition for any individual if they choose a secondary option. It just so happens in this case that secondary option is a religious school. And then if you say that the school is religious and that we can't give it to them, we can't give them tuition assistance on the basis that they will go into the school and they'll be practicing their religion, that is fundamentally opposite and contrary to the law, because the fact that they happen to practice the very same religion of that school is irrelevant. What if they were going to a school that it was a religious school and they did not practice that religion, but still they were getting a public education that was quantified and qualified? Would the state then say, oh no, you can because it's a different religion? No, that's not what Chief Justice Roberts is allowing in this case, as well as the 6-3 majority decision. And he basically goes on to say that the funding restrictions in those cases were solely based on religious discrimination, while the challenge here imposes a use-based restriction, which basically says you're using this school and we're going to restrict you for using that school, and you can't do that. So Trinity Lutheran and Espinoza held the free exercise clause forbids discrimination on the basis of religious status. Justice Breyer, dissenting, goes on and states that, hey, well, you're forbidding the government from making any law respecting the establishment of religion, and it forbids them to make a law prohibiting the free exercise of religion, which is found in the founding writers and the documents. So the court, he says, is paying no attention to the words of the first clause while giving exclusive attention to the words of the second clause of the First Amendment. On the other hand, the Establishment Clause commands a separation of church and state. We understand that. So the state cannot aid one religion or aid all religions or prefer one religion over the other. But in this case, I disagree with the justice, because it is not about a case about religion. It is a case about tuition that just so happens to be funding the student who goes to a religious school. And if that argument is true, what he's making with Everson versus Board of Education, favoring one religion over the other, again, my point would be that if a Christian kid is going to an Islamic or a Buddhist school to receive an education, would you restrict them then because they're not actually practicing that religion? Right? They're getting an education. So you wouldn't restrict them in this case. So why should you restrict them if they're going to a institution that happens to be an agreement? They happen to be in agreement or align themselves as far as faith-based. So I don't agree with Justice Breyer on that point. Furthermore, Justice Sotomayor goes on to state that she thinks that the court is trying to dismantle the wall of separation between church and state that the framers fought to build. And she agreed with Justice Breyer Justice Breyer. She says, first, the court should not have started down this path 5 years ago in 2017 with Trinity Lutheran Church of Columbia versus Comer. And then she assumes that the Establishment Clause violation of the court revolutionized this free exercise doctrine by equating a state's decision not to fund a religious organization with presumptively unconstitutional discrimination on the basis of religious status. I don't think that is actually a challenge to the fundamentals of the First Amendment that the founders actually thought about. I think that this would be a preemptive strike going in the absolute opposite direction. And I am really over right now. So anyway, she goes on to say that she creates this option that the court does leave options to main. For example, under the state law, the school administrative units cannot feasibly operate their own schools, may contract directly with a public school in another SAU or with an approved private school to educate their students. Again, that is sidestepping the whole issue that whether it's another private school, whether it's a school in a different unit, that the fact of the matter remains that you cannot discriminate a person's choice on the basis that they happen to choose a school that is religiously associated. And I agree with the court in that sense. So, moving on, these are my references. So I received that from OES, which is L2 Supreme Court, the Justice Supreme Court Center, Legal Information Institute, as well as LexisNexis. And the case site is there. Carson v. Makin, 596-2022, 142 S Supreme Court, 1987-222. And thank you again for listening. I'm Curtis Walker, and that is my Gmail, and that is my email. I hope that you enjoyed this case, and see you in class.